It's a beautiful day, and I am delighted to welcome you to a new episode of the Computational Antitrust Podcast. My name is Thibaut Schrepel. I am a faculty affiliate at Stanford University Codex Center, an associate professor of law at the VU Amsterdam, and the creator of the Computational Antitrust Project, which explores how legal informatics can benefit antitrust law. The project brings together over 65 competition agencies and about 50 academics on the advisory board. Every month or so, we publish an academic article on computational antitrust. You can find all of these publications at computationalantitrust.com.
I am Teodora Groza, a PhD student in competition law at Sciences Po, a research fellow for the Track AI project, and the editor-in-chief of the Stanford Computational Antitrust Journal. It's a beautiful day where I am too, and it also is an exciting one because, as Thibaut will tell you, today we have a very special guest on our podcast.
So yes, indeed, our guest today is none other than Cary Coglianese, a professor of law and professor of political science at Penn University, also the director of the Penn Program on Regulation. Now, as you may know, Cary is known for his work on administrative law and regulatory processes with an emphasis on empirical evaluations of alternative ways to regulate, including the use of algorithms and AI. Cary, as you may recall, already appeared on the podcast in 2022 because he co-authored a paper for us entitled Antitrust by Algorithm, and Cary is a member of our advisory boards, so we are very pleased to welcome Cary for the second time on the podcast.
Now, because Cary is a regulation superstar, our conversation today revolves around AI regulation, but also how this general conversation plays out in the antitrust sector. We'll talk a lot about leashes, how the future will look like, but also about what the challenges to implementing AI tools in antitrust enforcement may be. I hope you'll enjoy our conversation and that you'll stay tuned for our future episodes. Cary, it's great to have you with us. In 2022, you co-authored a paper for our journal which was entitled Antitrust by Algorithm. Now, fast forward to 2025, we're in the era of AI. So we thought it was high time to have you over for a discussion on antitrust by AI, not algorithm, where we explore how your recent work tackles AI regulation, but also how AI plays a role in lawmaking and law enforcement. This conversation will be divided into parts. We'll start by a couple of general questions about AI regulation, and then we'll move on to the specifics of antitrust. So, to get us started, AI regulation is very much a buzzword these days. We see it absolutely everywhere. But it's important to know that it doesn't come in only one flavor. There's an entire spectrum of different techniques. In a recent paper, you explained the difference between two metaphors, one of guardrails and the other one of leashes. Can you tell us a bit about that? And can you give us perhaps two examples of concrete tools which fit within each of these categories?
Sure. Well, first, let me thank you for the opportunity to be here and talk with you. I'm looking forward to the conversation. And thanks also for referencing my 2022 paper that you published with my co-author, Alicia Lay, who I want to give great credit to for the work as well. And you're right, we did talk about algorithmic tools, and as you say, we're now in a different era altogether. I guess what I would say, first of all, by way of definitional clarity, we were talking about as algorithmic tools might have been thought of as sort of traditional AI that was very task-oriented and very specific, to what's happened since 2022 is really the release of generative AI, these foundation models that are what I call multifunctional and have actually obviously captured the world's attention so dramatically since that time. So 2022 is in AI terms almost an epoch ago. and yet, one of the things, and this goes to your question of this paper that I have forthcoming in the journal Risk Analysis, co-authored with Colton Crum, who's a computer scientist at Notre Dame, which we distinguish between governance approaches as guardrails or governance approaches as leashes, like a leash on a dog. And what's striking is that all of our language and metaphors about governing AI are focused on an older era, really. And the term guardrails is tossed around constantly as what people are searching for when they're thinking about AI regulation. And what we say in that paper is that that's the wrong metaphor. Guardrails are fixed devices that protect people on roadways. Real guardrails are fixed on roadways, and they provide constraints and limits on whether your vehicle can go off the roadway or over a cliff, right? But the thing about AI is, first of all, it's not a fixed single technology, and it's also a very dynamic technology. We can't even chart out what the road is to put the guardrails on. And so I do think metaphors matter because it shapes both what kind of solutions we look for, as well as what kind of expectations we have from governance strategies. And what we argue in this forthcoming paper is that it's just unrealistic to think about anything that's going to be in the regulatory sense operating in a fixed guardrail fashion. And that what we really should be doing is thinking about regulation that's more dynamic and flexible itself, that allows the technology to develop, explore, much like if one were walking a dog, which is, by the way, a type of intelligence too, right? And allowing it to explore and pursue new pathways. But nevertheless, what a leash has is, in addition to that flexibility, it has a human at the other end of it. And when necessary, it can be pulled back or steered in a certain direction. And we can, I think, benefit a lot from thinking about regulation as leashes rather than guardrails.
Yeah, let's talk about leashes. So depending obviously on of the size of the dog, it is not always obvious, from a third party perspective, who's walking and who's following who, right? It could be that it gives the impression that the owner is very much struggling, which may be very relevant when it comes to AI. And depending on the models and whether the AI system is deterministic or not, you may have different dynamics. But in any case, if you have a leash, the assumption is that we want some sort of safety, right? It is there in case there is a little girl walking down the pathway and you don't want the dog to attack the little girl. This would be extremely bad as an outcome. Now, my question is this: do you think that the discussion out of the Paris AI Action Summit has moved that discussion away from AI safety towards unleashed AI? Or is it still relevant and something that we should consider as scholars?
Well, I do think that the general discourse at the Paris summit shifted away from the focus on safety, that at least as a dominant emphasis as it had been on previous summits. But I don't think we should say that it's actually disappeared. I think, and this goes to another forthcoming paper that we have, Colton Crum and I have written and have yet to release, but it should be out very soon, in which we say that the way to unleash AI innovation is to leash it. That is, I do think that the collective industry and industries that are developing and using AI tools either do recognize or have to recognize that safety is going to be vital for the development of this suite of amazingly dynamic technologies that we're seeing. Yes, there is a global race on for dominance in artificial intelligence. The Paris summit, I think, reflected the geopolitics surrounding AI. But keep in mind, there also were many more countries involved. There were more countries that signed on to the declaration at the end and signed on to any prior declaration related to AI. And I think companies as well recognize that if they want to avoid the backlash kind of regulation that might be blunt and ill-considered, that might follow from some kind of catastrophe or real public disaster related to AI, that they need to still proceed in a responsible manner. And interestingly enough, if you go back and look at the policies of even the first Trump administration, and I know obviously the US was an outlier in not signing on to the Paris Summit Declaration. But if you go back to the first Trump administration, the president had signed several executive orders indicating that in order to promote the industry, you also needed to ensure that it was trustworthy and reliable and had credibility and safety. So I don't think those imperatives will disappear, even though they aren't quite front and center right now. I do think that change, I mean, it's always been a very competitive industry, couldn't be in some ways more competitive, maybe not necessarily in the antitrust sense, but in the geopolitical sense, certainly it is today. And, safety, I think, has to be part of that conversation, because otherwise you run the risk that one firm's really horrible mistakes may well punish, in some sense, the whole industry if there's some crude form of regulation imposed in reaction.
That came to mind is that if we talk about AI safety, we also lean into this kind of concept of responsible AI. And it seems that everything I've read so far on the subject is trying to argue that we need responsible AI. And of course, we understand why, because of all the dangers. But I was wondering today, and so I'm just serving you the questions because I didn't come to a conclusion. Should we always be responsible? What does it say about us as a society? Is that just okay as well if we have sandboxes and places where we can use AI in a way that is not responsible at all, just for the sake of it? What do you make of that?
Well, I guess it maybe depends, and the good lawyerly answer here, it depends on what we mean by responsible AI. And I do think that there's need for a balanced approach and a flexible approach, but also one of vigilance. Okay, so what do I mean by that? I just mean that responsible AI doesn't mean putting up in place roadblocks to the progress and advances that such technology can deliver. I mean, if we can use AI tools to detect more accurately cancer on radiographs, let's put it that way, right? It wouldn't be responsible to put in place some barriers to that development and that use. And on the other hand, if AI is being used in indiscriminate ways, or in ways that are unduly discriminating against people on racial grounds, for example, then it would be irresponsible not to put in some kind of protections. So I think that responsibility is kind of a two-edged sword. We don't want to slow down the good that can come from AI innovations. But on the other hand, we want to make sure that there are humans overseeing it, and making sure that it's not straying into areas that are undesirable and untoward. And again, this is where the leash concept, I think, is really better. We don't want to just say, there's a fixed, like, never go anywhere, because keep in mind, oftentimes the alternative to AI tools being used for certain kinds of functions or decision making are humans, and humans are not perfect at all either. And what we really want to do is see a development of this technologies so that we can improve on our existing human capacities, but not actually come along with side effects and negative consequences that make things worse.
Yeah, and I think that becomes very obvious when you then tackle the other side of the coin, which is public agencies using AI, right? Because I guess then there is a consensus that we clearly do not want our governments to use AI in a way that would hurt us, the citizens and consumers. So, and you've worked extensively on the topic. Now, my question is, when it comes to the use of AI in the public sector, what are the most striking examples of good uses of AI?
Yeah, well, one thing I should say is that, it's certainly something that in another study that I'm working on and soon to be releasing, we've documented just the almost exponential growth of public sector use of AI by the federal government, at least in the US. And of course, there's a lot more use going on at the state and local levels as well. So government agencies in the US and around the world are starting to use these increasingly. That said, out of about 1,700 use cases that my co-author and I have identified at the federal level in the US, we can't really find any where there's a human out of the loop. And I think that's a good thing. That means there's a leash there. There's some attention to what does that mean? It means that, for example, one of the areas where AI is being used the most outside of sort of research functions, and that's sort of the predominant use in the public sector right now, but where it's used for decision support in ways that can have some direct consequences for people is in regulatory enforcement. But there's never automatic decisions being based upon the results of AI tool. There's always, a follow-up by inspectors. It's used to target and deploy limited, inspection resources to identify violations. One study has shown, for example, that the Environmental Protection Agency could identify water pollution violators much more effectively by using AI tools. In fact, finding 600% more violators than just the kind of crude techniques of sending inspectors out on a random basis. So there's demonstrated advantages to deploying scarce governmental resources in a more effective and efficient way. But it's also important, as you say, to continue to have some kind of backstop where some human is at the end of the leash, able to see how it's working. Doesn't mean there haven't been mistakes. There have been some famous errors with algorithms in the Netherlands, in Australia, and even in the United States, in states like Michigan with benefits determinations. And so responsible AI principles apply, especially in the public sector.
How active do you think the human is in the loop? And I'll just ask, for when it comes to the United States, do you think officials and people working in the public sector in the US, when they see that AI comes with a proposal as to what to do or what should be the decision, do you think they will accept that as being true because it's AI and it computes millions of data? Or on the contrary, would you say that people in the US may be kind of skeptic because it is AI and a black box, and may have a tendency to reject that?
I think there's some bit of both, depending on where you're looking at it. But I think, I've talked with some agencies where they really don't trust the algorithmic determination of where to send inspectors, and then others that really are following it. I think that's probably human nature, that there are some people that are more skeptical of technology, some people are more confident of their own abilities.
Yeah. But there is no cultural trait that you would say clearly characterizes the US as a whole.
I'd be reluctant to generalize as a whole. And I don't know that we have enough research to really say what the overall trends are, in part because these are still, the public sector is using AI tools more and more, but they are still well behind the private sector in this regard. And by the way, when I'm talking about public sector uses, I'm putting to the side defense and national security uses, about which I have very little information simply because it's classified. I do think from what reports we can glean, there's much greater work going on in the defense and national security sphere.
So what's clear from your discussion is that the use of AI in public administration is pervasive. We see that globally, the antitrust authorities are very much preoccupied with AI. And the most concrete example of this preoccupation is the investigations they opened into the partnerships between AI firms and big tech players. Now, I want to go back to your metaphor of leashes versus guardrails, because one, I think it's a great metaphor, and two, because I think it's really funny to imagine regulators wrapping leashes around algorithms. So my question is, how do you think this metaphor plays out in antitrust specifically? How could regulators use leashes as opposed to guardrails in the antitrust context?
Well, I think one area would be in calling on the firms themselves to hold on to a leash when they are using algorithms to conduct market transactions. So there's a lot of interest and concern about algorithmic collusion and automated collusion by these AI tools. And that seems to me to be a really ripe area for regulators to say to firms, you need to have in place in your organizations systems that will oversee your algorithms and protect against collusive behavior that you might not intend as the designers or developers or users of those AI algorithms, but which, once you set those algorithms loose, they may well engage in that, especially as we move into a realm of agentic AI today. I do think it's appropriate for antitrust authorities to start exploring ways that they can compel firms to make sure that their algorithms are tethered appropriately so that they avoid the kind of antitrust behavior that regulators would be concerned about if there were humans engaged in those transactions.
Do you think we are close to the level of trust required for authorities to defer to firms to set up their own leashes, or we have a long way to go before we can move towards a sort of do-it-yourself antitrust where the firms can self-regulate and self-leash themselves?
Well, in some ways, I'm not sure whether we have an alternative because, the alternative might be nothing at all. Okay. But you're right that there's always concern about trust. The key is, and this is why I always say, with respect to regulating AI, we need flexibility, but we also need vigilance by the regulators. And this is, again, why a guardrails approach, I think, is really, really a bad metaphor, because a guardrail is something that you put in place and it stays in place and it offers its protection in a passive way, right? But what a leash means is you have to go and walk along, right? And as a regulator, you need to make sure that somebody is walking along as well, and that requires vigilance. So, uh, you know, I don't think in any regulatory sphere you can say that trust is sufficient. If it were, then you wouldn't need regulation. And regulation occurs when there's a misalignment in incentives between the regulated entities and the publics and the society. And now we have sort of another layer of misalignment that can occur between the AI tools and even their designers. So we've got to build in leashes all along the chain here and vigilance all along the chain too.
Yeah, I think what makes antitrust really special as a use case for your metaphor is that the law is so open-ended that it works as a leash by default. There are no strict rules embedded in the law. Everything is very open to debate, interpretation. Hence, it functions as a leash by default, which forces us to think how we can improve it. And as you talked before with Thibault, AI is used a lot in law enforcement in lots of fields of public administration, but it can also be used in the specific case of antitrust. Now, just to build a bit on your work on the use of AI in the public sector, you document the emergence of management-based approaches to implementing AI tools in the public sector. And you talk about how there are persistent concerns about how AI tools could impact good administration in terms of fairness, transparency issues, trust issues, and so on. Could you tell us a bit more about what antitrust agencies can learn from these management-based approaches to implementing AI tools?
Sure, right. And then it follows, I think, well on our discussion in the last question, because a management-based approach to regulation doesn't wait for the antitrust violation to occur. It doesn't, and then go in. It's not reactive, but it's preventative. It's applying some kind of requirements for regulated entities to put in place systems to identify risks. Now, the risks that management-based regulation has been used to address in other realms have been things like food safety risks of chemical industrial accidents, risks of terrorism vulnerabilities. These are very serious risks, and yet, they are governed by leash-like regulatory structure where the public regulator puts in place requirements for risk management of the industry. And the industry then needs to develop its own internal plans and analyses of those risks, follow kind of a plan, do, check, act, Deming circle model of identifying where hazards are developing and what the firm can be doing to avoid them. This is something that is appropriate when there's no one-size-fits-all solution to a regulatory problem, and where it's also hard to get good, firm performance metrics. And I think that's the state we're in with artificial intelligence broadly, and I think it would also apply with respect to antitrust concerns about AI algorithms as well. Rather than just waiting, what regulators in the antitrust world can do is could put in place proactive, preventative requirements that firms, as part of maybe even an overall AI risk management system, be on the lookout for and be testing for anti-competitive behavior by algorithms to the extent that those algorithms are driving or influencing market transactions.
Yeah, and on that, I think it's highly relevant in the EU context as well, with the Digital Markets Act, which is kind of a guardrail, or at least trying to put out some big principles as to what companies shouldn't do. But obviously, the market evolves. And in the DMA, we have 10 sectors that could be potentially covered if you are providing a core platform service within. But in any case, what's very striking is to see that generative AI is not one of the 10, because the DMA was drafted before Gen AI was even on the radar. So regardless of whether or not you have a DMA, I think you have no choice but indeed to come eventually back to the leash metaphor and to have the capacity to work with the companies and understand what they do and document that. Which brings me to your 2022 article, Antitrust by Algorithm, because at the time, you wrote in the paper that the key institutional challenges for the agencies were to build the organization within to have the capacity. That was number one. Two, to avoid the legal pitfalls of using algorithms and to try to predict what will happen when in fact it is really hard. And three, to establish trust so that companies will trust that they have a good administration in place. Now, 2022 is something that takes us back to probably 25, 30 years ago now in AI age. So would you say that the very same institutional challenges are the ones that agencies are facing in the Gen AI world? Or is there any other challenge that becomes very obvious now?
Well, broadly speaking, they are the same challenges. But as I have argued, I've got another paper called Regulating Multifunctionality, where, again, my co-author, Colton Crum, and I argue that the challenges with respect to Gen AI are really qualitatively the same as with AI. It's the heterogeneity of AI, it's the dynamism of it, but this just goes on steroids, okay? So I think the same sort of challenges do exist, but they are qualitatively more pronounced in the world we live in today. You mentioned that the concerns about public sector use of AI tools, and I think it's worth noting that very few public entities probably have the internal capacity right now to develop the sophisticated tools themselves, and so they have to rely on private firms. And I think there's real importance to make sure that there's leashes in place in the procurement process so that there's adequate disclosure both from the private firm to the government, and also the ability for the government to be able to disclose adequately information to the public or to the courts as needed, so that it's something that's possible to show that these tools are being adequately monitored and validated, that there is somebody at the other end of the leash. So that's still, I think, really important. If anything, it's more important today than it was in 2022.
Yeah, and it again brings us back to the discussion about trust, whether judges will be willing to accept AI generated evidence, and the kind of institutional settings that you need within your agency to come up with the standards that is deemed to be good enough for the court indeed to accept it.
Yeah, can I just add, by the way, that I wrote another paper called "From Negative to Positive Algorithmic Rights," and again with my co-author in that case, Kat Hefner, and I argued that what we're seeing with AI today is very similar to what we saw with the development of other advanced technologies in the past. For example, DNA typing was viewed with great deal of skepticism by the courts when it was first put in place. And you can go back to the 1980s and see court decisions in which they were actually resistant to the use of DNA in legal proceedings. And yet today, by and large, DNA is considered the gold standard for evidentiary purposes. And what has changed? What made that possible were things like validation, the building of trust, the demonstration of evidence, and so forth, and the assurance that DNA is being handled in a responsible manner. So I think if we can see forward a way that AI can follow the same path, we might find, the courts accepting AI, not only accepting it, but actually maybe asking, well, why wasn't it used in certain instances? We may see that in the coming years.
Yeah, because it's hard to imagine that in 2050, courts won't be rely on AI at all. I mean, who knows? We'll see, but I doubt it. Now, the question is, if they are to rely on AI, what can we do along the way so that when we minimize type 2 and type 1 errors, right? And those are the important questions, which brings it
Exactly.
back to the counterfactual, as you answered and pointed out many times in our conversation.
Yes, so I'm glad that you two brought up the issue of the relationship between AI and courts, because I want to ask an even broader question about how AI changes regulation in general. And throughout the entire conversation, it seemed to me that we argued several times that with AI, things are moving so fast, regulators don't have enough information, that maybe, just maybe, this will be the end of guardrails altogether, and all regulation will be in the form of leashes. Would you argue that this will be the case? And that in the future we'll only regulate through leashes and guardrails will be a thing of the past?
Well, with respect to AI in particular, or with respect to regulation more broadly? I mean, I do think more broadly, we're likely to see transformations of regulation through the use of AI tools that in other spheres. I mean, the algorithm and the AI tool may become the rule rather than something that's written down on paper. I mean, which shouldn't be too surprising in a way, because a law or a rule is itself a type of algorithm. It's just a crude one. We've had algorithms forever. They're called laws. They're called procedures, right? And now we just have much more sophisticated ones. But if they're validated and built around socially accepted values, I think we could see more generally AI becoming a substitute for what we currently have as rule-based system that's, words on paper that are administered by humans.
You've mentioned some, and in fact, many of your co-authors along the way, right? How are you choosing those co-authors? Is it that you knew them and then after a couple discussions thought, well, let's write this paper together? Or do you have more of an idea for a paper and then you're like, okay, I do need someone, let's say a computer scientist with this kind of technical expertise, and then you reach out to someone?
Well, I have a very complex AI tool that chooses my collaborators. No, I'm just
Is that your brain?
Yeah, that's right. There we go. It probably follows a more stochastic process, but I think it is probably the former of just engaging in conversations with people. Ideas germinate in those conversations, and if collaborator is willing to come along and help see that into a final paper, that's great. I mention them because they've been partners in this work, and I want them to, even though I'm the one in the podcast, I want to make sure that these papers of mine that I'm talking about are not fully mine, but in many cases are ones that I've been fortunate enough to work with some really smart people in a collaborative process.
And we see sometimes, especially amongst the computer scientists, that they have up to 100 co-authors on a single piece, right? The governance behind that must be quite sensational and interesting to analyze.
Yeah. I certainly don't have that many. I mean, I usually have one at a time or two at most.
Yeah. All right. Well, thank you so very much for the conversation. Again, for everything you've been doing in the space. I think it's of very high value.
Very kind and generous of you to invite me to participate in your podcast. I appreciate all the work that you're doing too. And these are interesting times for anybody working on regulation and certainly intersection between technology and governance. So
yeah, I feel lucky. We have so many regulations and cases, plus AI and exciting and promising technologies, that there is a lot we can do as legal scholars.
Absolutely.
All right. Well, to everyone out there, take care of yourself. And if you can, someone else too. Bye-bye.